Go.
Comparisons between digital laws in the UK and in India. The IT Act 2000 in India. The IT Act began legislation surrounding cyber laws in India. It commenced on the 17th of October 2000. There have been several amendments to it over the years, but the original act gave recognition to electronic records and digital signatures in India. Some of those later amendments and other related legislation to digital laws in India include the IT Act Amendment of 2008, which added new elements like sections 66A and 69. It was part, and one of the other provision. This amendment was passed on the 22nd of December 2008 and signed into law on the 5th of February 2009. So yeah, 16th anniversary. Future acts and other legislation include the Intermediary Guideline Rules 2011, which introduced more rules surrounding personal information, such as classifying or separating personal information into that which is sensitive and that which is more general. Others include the IT Rules 2021 and the Digital Personal Data Protection Act, which is related to the Digital India Act, which both are from around 2022 to 2023, which has been started to be implemented since around then, I believe. Also, the Cyber Appellate Tribunal was set up at the time of the original act. It was set up to hear disputes and appeals relating to the IT Act and was stated under Section 48, Part 1. There have been aspects of the Act, though, that have been criticized by various people. And one section did get repealed. Well, not repealed, did get struck down eventually. One case was Shreya Singhal v. Union of India. Shreya Singhal, a law student, challenged Section 66A of the Act, defending several people who were arrested under that section and maybe others as well. They included a professor in the state of West Bengal who shared or created a drawing of the chief minister and a person who criticized the shutdown in Mumbai for the funeral of Bal Thakurte. Shreya Singhal filed a public interest litigation, but as part of this, the Section 66A gives a penalty of imprisonment of up to 3 years with fines to anyone who publishes offensive, false, or threatening information. Many have felt that this section was being unfairly used by the government to silence criticism of it. A related case that also helped in eventually striking down Section 66A was the arrest of Asim Trivedi, an activist who was arrested under the section. He created cartoon drawings, such as the one on the top right, that depict corruption in India. He uploaded his drawings on sites, including the one for his campaign, Cartoons Against Corruption. He was arrested specifically for sedition, meaning incitement of resistance to or insurrection against lawful authority. These cases sort of combine in meaning in striking down the section, which was struck down on the 24th of March 2015, being declared by the Supreme Court of India as unconstitutional. However, it is still used. It is logic is actually still used, but there are instances where it has been claimed that it has been used in some instances, but officially it was struck down then.
The UK's GDPR is a legal framework covering the processing of all personal data online within the UK, alongside the UK's DPA of 2018. These laws specify how all personal data is supposed to be processed online, and the rights and entitlements of the subject of that data, personal data. And the purpose of these regulations is to protect the subject of that data, the person involved with that data, and specifying rules relating to the free movement of personal data throughout the UK. Some key points include the guarantee that data collection by controllers is lawful and fair. One of the rights of the data subject is the right to be informed, which is basically the obligation of the controller, the processor of the data, to inform the subject of the data that the data has been processed and provide them with means of contacting them and a contact detail for the data protection officer and the reason for processing their data. Other rights of the data subject include the right to object, which is in Article 21 of the GDPR, which states that the data subject can object the data being processed at any time, depending on the specific circumstances of the data, and if the processing required consent that wasn't given initially, or if the data processing isn't compliant with Article 6 of the GDPR, which covers the lawfulness of the data processing, then the data subject can object. It can also be automated via online. Another one of the data subject's rights is the right to withdraw consent, which is very similar in Article 7, which describes how the withdrawal of consent should be as easy as giving the consent in the first place for the data collection. And withdrawal does not change the lawfulness of the previous processing of data. The right to access data, which is basically where the data subject has the right to get their data or a copy of it from the collector of the data or the controller, as well as the reason for it being collected and the categories or the names of the recipients of the data if it was shared. Some of the flaws and criticisms of the GDPR are basically that they have very blanket fines. So for if there isn't a number given, then there will just be a standard maximum fine given, or that to comply with the GDPR, a lot of administrative work has to be done, as well as the organization, as well as the organization having to pay high compliance costs to be certified. The UK's Data Protection Act of 2018 is basically, it goes along with the GDPR, it's a more up-to-date version, and it implements the vast majority of the GDPR law, as well as the EU's LED and DPD Acts, which are to do with law enforcement. And it covers a much wider scope than the GDPR, like national security and immigration. So an example of where the GDPR is applied was in an incident in 2018 where British Airways was breached by a group of hackers who diverted customers to a fake website, which then compromised all of their login and payment and booking details of over 500,000 people, which resulted in the ICO fining British Airways 183 million. And basically, what happened in the UK was, because the GDPR is so strict, a heavy fine was put down because of all the blanket fines. And as well as the GDPR enforcing public disclosure and reporting of all the company's data. So the fine was larger because the number of victims had to be released under the GDPR, as well as the GDPR having a larger focus on the rights of the individual natural persons, which means that the consequences were much higher because they have a much higher bearing for the individual's rights. Whereas in India, it would fall under the IT Act 2000, which has much lower fines than the GDPR in general. So the total fine would be much lesser. Whereas And India has a much less focus on consumer-related penalties and more focused on general cybersecurity.
The Computer Misuse Act 1990 is the UK's main law for hacking and offences similar. So it covers 4 main offences. The first is unauthorised access to computer material, which is more commonly known as hacking. Then the second one is unauthorised access to unauthorized access to computer materials with intent to commit a further crime, which is like downloading a virus or blackmail, etc. Unauthorized modification of data. This means it is illegal to change any form of data within the United Kingdom without permission. Then finally, if making, supplying, or obtaining anything which could be used in computer misuse cases, which, aka, don't make viruses, don't sell them, don't own them. Sorry. Then you've got, in India, it's also under the IT laws, which is like their main mega one. So you've got Section 43A, which criminalizes access to computer by individual without explicit authorization. So, aka, don't use a computer without permission. Section 65, this makes it illegal to conceal, tamper, or destroy computer source code to cause harm. Computer source code is defined as programs, commands, designs, and layouts of any computer resource. As you can see below, you can get punishment is 3 years in prison for both of them, or for section 43 it's 5 lakh rupees, which is roughly £4,500, just over it. Then, or for section 65 offences is £1,200 roughly. Then you've got section 66C, which is don't use anybody's password or any unique identifier. This can get you 3 years in prison and /or a fine. Then you've got 66D, which is don't cheat or impersonation using a computer. The punishment is 3 years in prison and /or a fine. Then we have section 70, which is don't hack anything that involves critical information infrastructure. aka, do not hack the government, do not commit cyber terrorism. This carries a sentence higher than others at 10 years and an undisclosed or unknown fine amount. Then you've got section 72. This section affects ability to access information without explicit consent. A breach of this law can get you 2 years in prison or a fine of 1 lakh rupees, which is just under £1,000. So, you may be wondering, what are the key differences between India and the UK in this aspect? In the UK, as previously said, fines are normally significantly higher. And however, you've got higher prison sentences in some cases, and there's significantly more offences when you look at them. The Computer Misuse Act is targeted for criminal purposes and stuff like that, which IT Act does contain, but they do have other aspects. And also, the IT law is considered to be more recent, as it has had a major upgrade in 2008, while the Computer Misuse Act is currently getting reviewed as if it could potentially need replacing. So this moves us on to the scenario. Kane Gamble is a hacker with the group Crackers with Attitude. This targeted US-based, departments such as their intelligence and Department of Justice. They target several major players there, including the directors of several ones. They would use their information gained to access email accounts and impersonate them in call centres, and they would also hack into their smart technology devices. They were politically motivated to do this after sympathising with the Palestinian cause, making it a case of cyber terrorism, and in fact the judge also called it that. Several findings were also uploaded to the infamous WikiLeaks. So what would happen in the UK and India? In the UK, it's quite simple. He got 2 years in prison in Belmarsh, not a nice place, nor a nice prison. He is also banned from ever entering the UK, and you can see what he's been charged with there. Well, in India, it's slightly different. You would get lightly charged for cyber terrorism, accessing information without consent, using somebody's password, I believe, as well as impersonation of somebody through a computer, aka the social engineering side. This would roughly get him 18 years in prison when you look at the combined ones that I've got there, but that's for one of each count, so it could potentially be more. And that is how he would go in India. Next.
Or RIPA, which allows certain public bodies to conduct covert surveillance and conduct mass surveillance of digital communications through emails, social media messaging, text, transcripts of video conferences. They can also be granted access by internet service providers to customers' digital communications without the customer knowing or consenting to it. They can also demand that the ISP installs equipment to allow them to do so at the expense of the ISP. They can also access encryption keys to encrypted data so that they can decrypt it. And they can also keep any data gathered by an interception warrant and even the existence of an interception warrant completely secret to the point where it doesn't even need to be disclosed in court. So what is meant by covert surveillance is basically spying on someone without their knowledge. This can be done with listening devices, wiretaps, drones, hidden cameras. This can also be the interception of post, such as letters and parcels, emails, texts, social media posts, and phone calls also come under covert surveillance. Covert surveillance could also go as far as informants and undercover agents, which will follow and spy on people. These are known as covert human intelligence sources. So here we have Section 49 of RIPA, which allows for law enforcement to request the mandatory disclosure of encrypted data from digital devices, such as a phone PIN, a laptop password, or a file encryption key, for the purposes of crime prevention and national security. Law enforcement must, however, meet the legal requirement that the notice is only issued to prevent or detect a crime that is necessary for the investigation of that crime, and they have reasonable belief that the subject of the Section 49 notice actually has the PIN to be able to follow the Section 49 notice. The notice can also only be given if it's deemed proportionate to the needs of the case. So as long as the benefits actually outweigh the intrusion of privacy of the notice's subject, then it can be issued. The punishment for non-compliance under Section 49 is a prison sentence of up to 5 years. Here we have the Information Technology Act of 2000 from India, Section 69 and Section 69B, which will be touched on in the next slide. This allows central government and state government themselves or state officers authorized by central or state government to intercept, monitor, or decrypt any information generated, transmitted, received, or stored in any computer system for the purpose of security of the state, friendly relations with other foreign states, public order, investigation of an offense, and defense of India. Anyone in charge of these of a computer must provide access to their computer or any data on said computer when called upon. And anybody who fails to comply with Section 69 will be given a maximum prison, or could be punished with a maximum prison sentence of 7 years and a fine which is undisclosed. Section 69B is very, very similar. To the point where the only difference really is the focus, which is more on cybersecurity, and the punishment given. The focus is mainly to prevent the spread and intrusion of a computer contaminant, so like malware, unauthorized access, or even denial of access to a computer. And the punishment here would actually be less. It would be a punishment of up to 3 years in prison and a fine of up to 1 crore rupees, which is about 92 grand. So the similarities and differences here, the prison time in the UK is lower, and there are fines in India, and who conducts these are different. So in the UK, Section 49 or RIPA is conducted by the police, whereas in India it must be authorized by central or state government. Both, however, do not need to be disclosed in court, and both allow for covert surveillance. Here's a scenario where Tejan was investigated for supplying Class A drugs and money laundering, where 4 devices were seized. However, an iPhone and iPad could not be accessed because of a PIN, which he had refused to give up, not complying with Section 49. Because he did not comply, he was given 8 months in prison for failure to comply with Section 49. However, if this had happened in India, since it's not a cybersecurity issue, it's an investigation of an offense, Tajin could potentially be given a maximum sentence of 7 years in prison with an undisclosed fine, which would probably be pretty hefty. In my opinion, 7 years is maybe a bit much, but I don't know.